to do other things in order to promote the inclusion. One possibility, of course, is the mechanism of strengthening institutions, for example, promoting the independence of courts. But not only the independence of courts, but also alternative dispute resolution mechanism, or, for example, special courts for the small businesses, or small claim courts, or mobile courts, as has been the reality in some parts of Brazil, where the courts move to remote areas and eventually provide people with possibilities to solve disputes. One additional area is the so-called legal education, not necessarily refer to legal education to professionals, but so much legal education to stakeholders. So letting people know what are their rights, letting people know how they can enforce their rights, letting people know where are the institutions where they can enforce their rights. So making the effort to educate in the broader context of the verb about the rights is one way, of course, to promote inclusion, creating opportunities and equity. Through the law, of course, opportunities can be created. Examples that come to my mind are in El Salvador. As you know, the state in all parts of the world is the main buyer of services and goods. In El Salvador, the government decided to set aside a percentage of the governmental procurement only to be granted to small, medium enterprises that had been incorporated in the recent year. So through law, they created an opportunity for the informal sector to migrate to the formal sector. Another example of how opportunities can be created that comes to my mind is the so-called conditional cash transfer programs that have been very much promoted in many parts of Latin America, for example in Brazil and Mexico, whereby cash is given to poor people provided that they show, for example, that their kids had gone to school or that they have been vaccinated, and eventually through those mechanisms, in addition to cash, specific indicators of poverty are fought through that. Another possibility, for example, of creating opportunities has been through the business restructuring laws of many parts of the world, where businesses in bad conditions are allowed to be sold not only as an ongoing business, but also as piecemeal. And if you allow people to buy business by pieces, that can create an opportunity for the poor people to buy, a small store, for example, of a big drug chain, and eventually get into the formal market and start prospering and doing business. But the problem we face with the local law is that the local law, the changes implemented through local law can be unstable. For political reasons in many parts of Latin America and Africa, we live in a constant political pendulum. From the right to the left, when the solutions of the right doesn't work, then people vote for politicians on the left. When they come with populist or state intervention mechanisms that can be funded when the state has a lot of money, then it's very successful. But when that fails, then people move to the other part of the spectrum. And as a result of this political pendulum, eventually laws are changed. When the new administration comes in place, they can come and they can eventually remove many of the changes, many of the rights that have been recognized. It is not to say that local legal reforms need not to be pushed, need not to be encouraged, but more than local legal reforms can be undertaken. One possibility is, of course, through the international approach, which is the main topic of discussion in this context today. The experience with international legal systems in Latin America and Africa has shown that through international mechanism, eventually rights can be recognized, rights can be enforced, and it can be granted with a stronger push that sometimes the local legal reforms lack. An example of that is in the context of human rights. For example, through the international agreements on human rights, not only the typical rights of life and rights to not be punished without due process of law, etc., are granted, but more importantly, specific rights in order to fight poverty are recognized. For example, in the context of the Inter-American Convention on Human Rights, the right of property is recognized. But more importantly, the right of property of communities, the so-called community right of property and the right of property of indigenous people is recognized. The experience has shown that through the recognition of human rights, people have, of course, the right to identity, and as I pointed out, the right to property, even in the context of communities. But the experience has shown that that also has a very important impact locally. One example that comes to my mind is in Peru, where after years of certain administration, democratically elected administration that was running the country in some kind of autocratic way, after years of that administration refusing to comply with certain standards of human rights or refusing to enforce the decision of human rights bodies, the following administration decided to create an institution, so-called National Council of Human Rights, devoted specifically to monitor the compliance of human rights, but more importantly, to monitor the compliance of decision of human rights bodies in all the governmental institutions downstream. What that shows is that you have the impact of an international approach to recognition of human rights for everyone in the specific country. Another example that I want to point out is in the context of the so-called international minimum standards. The example that I want to bring to the table is in the context of foreign investments agreements. In many of the foreign investment agreements, the so-called bilateral investment treaties or free trade agreements with investment chapters, you have references there to minimum standards of treatment specifically devoted to foreign investors. For example, expropriation. According to many of these agreements, the property cannot be taken if it's not under specific conditions. One is it needs to be for public purpose, it needs to be on non-discriminatory basis, and it needs to be compensated in a specific way. It needs to be paid promptly, adequately, and appropriately. Another standard that is included in these agreements is that foreign investors are not supposed to be denied due process of law. They are the minimum standard of treatment, the so-called fair and equitable treatment, is supposed to be granted to investors. And in many agreements, a definition of that includes the prohibition to deny due process of law, to deny justice, and so on. The impact of these agreements, as you can see, the agreements are very much devoted to foreign investors, not so much to local people, but it has a so-called contagious effect. The local people start asking for the same treatment that eventually has been granted to foreigners, and it develops some kind of local political dynamic that promotes inclusion, opportunities, and equity. Another advantage that we can say about the international approach is the involvement of the civil society. As I mentioned before, in many instances when the local legal reform tries to create consensus, many of the organized civil society can face issues such as the one I mentioned. They might lack identity or they might lack recognition. Whereas in the international context, you have well-developed, organized groups that represent the civil society that eventually can push